Summer is when the cracks in vague parenting plans really start showing up. During the school year, the routine can cover up a lot. School starts at the same time. Pickups happen on the same days. Everyone knows the rhythm. Then summer comes. Now one parent wants vacation weeks. The other parent already booked camp. Someone is asking about travel. Someone else is worried about school starting again in a few weeks. And suddenly, both parents are looking at the same parenting plan and seeing two different answers. If that's happening in your family, the question isn't just who is being difficult. The better question is, does your order actually answer the summer problem in front of you? Because sometimes the issue is a clear violation. Sometimes the issue is poor communication. And sometimes the real problem is that the parenting plan is too vague, too outdated, or it's silent for the way your family actually lives now. I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group, where we help Florida families understand parenting plans, time sharing, and the practical next steps that come with them. In this video, I'm going to walk through how to sort out those summertime conflicts calmly, what to look for in the order, when a summer conflict may be an enforcement issue, when it may be a modification issue, what to document, and why waiting until summer is about to end can make everything harder. Just remember, this is general Florida family law information. It's not legal advice about your specific order. So let's start with the first thing summer usually exposes. The parenting plan may not be as clear as everyone thought. If your parenting plan only works when school is in session, it doesn't work. Most summer parenting conflicts aren't random. They come from unanswered details in the order. A plan can sound fair in broad terms and still fail in practice. For example, each parent gets 2 vacation weeks, but there's no rule for who chooses first. Shared summertime is granted, but no deadline for giving notice on changes. Camps are mentioned, but there's no language on who decides or who's going to pay for it. Exchange times exist, but there's no guidance for when summer schedules change. And that's where the conflict starts. Not at the emotional level, at the operational level, with assumptions. And 2 different assumptions create one predictable fight. So the move here is simple. Before you debate fairness, figure out whether the order is clear, silent, or it's inconsistent. That one distinction tells you whether you're dealing with a compliance issue, a communication issue, or a drafting issue. And once you see those gaps, the first places they usually explode are camps, travel, and shared expenses. Before you book that summer camp or the trip with your kids, check the time-sharing order in your parenting plan. A lot of summer fights between co-parents start after money is already spent. One parent pays for camp. The other parent says, "You never asked me." One parent books travel. The other parent says, "That's my week." Now, both sides feel justified and everyone is already dug in. This is why camp and travel conflicts are rarely just scheduling conflicts. They're usually 4 conflicts at once. Time. Does this overlap the other parent's timeshare? Authority. Who gets to make this decision under the order? Notice. Was a proper heads up to potential changes actually given? Cost. Does the order require shared payment? Or is someone assuming? If any one of those 4 is unclear, conflict is predictable. If 2 or more are unclear, conflict is almost guaranteed. So the practical move is simple. Before you book, before you pay, and before you demand reimbursement, run the 4-point check. Time, authority, notice, and cost. Summer plans can be practical and still create legal problems if they ignore the order. And when these decisions pile up in July, they often create a second problem in August: school year transition pressure. The week before school starts is the worst time to discover your parenting plan is unclear. Here's what that might look like in real life. In July, mom agrees to a 2-week temporary summer swap so dad can take a trip. No one documents how makeup time will work. No one addresses school week transportation when summer ends. Now, it's early August. Mom expects the child back on Sunday for school prep. Dad says the extra July time shifted the next exchange and wants to keep the child until Tuesday. School starts on Wednesday. Now they disagree on pickup, first day logistics, and who is responsible for getting the child to school. That's how July flexibility becomes an August school problem. What felt cooperative in summer can create conflict at the exact moment that structure matters most. So the practical rule is simple. If the summer agreement changes time sharing near the school start, lock down 3 details immediately: exact return date and time, makeup time terms, and first week school transportation. If those are unclear, the issue will usually get louder in August, not quieter. And once that pressure builds, the next question matters most. Is this a one-time conflict, or is this part of a repeated pattern? If your co-parent is late once, that's a bad day. If they're late every Friday, all summer long, that's an actual legal pattern. Not every summer conflict belongs in court, but repeated conflict is different from a one-time mistake. Imagine one exchange runs 45 minutes late because of traffic. That's frustrating, but it's isolated. Now compare that to this. Every Friday exchange is late. Makeup time is never honored. You get last minute running behind texts every single week. By August, your child is missing activities and the same conflict keeps repeating. That's no longer a one-off communication issue. That's a pattern affecting the child's stability. When these things come up, try to put it in one of 3 buckets. It's either an isolated misunderstanding, a recurring ambiguity where same confusion keeps repeating because the order is unclear, or a repeated refusal. Clear terms exist, but one parent simply ignores them over and over and over. That distinction tells you what to do next. One-off issue? Solve it proportionally. Recurring ambiguity? Fix or clarify the language. Repeated refusal? You may be in the enforcement lane. Look for the pattern. Don't build your strategy around one bad day if the real issue is repeating behavior over time. And once you identify the pattern, the next step is picking the right remedy. Enforcement, modification, or structured documentation before escalation. If your co-parent keeps breaking your summer time sharing schedule, filing a modification first may be the wrong move. If the current order is clear and not being followed, that's usually an enforcement question. If the order itself no longer fits real life, that's usually a modification question. Most parents lose time because they treat those like the same thing. They're not. Here's a concrete example. Your parenting plan says dad gets the first 2 weeks of July. Mom keeps the child anyway and refuses makeup time. That's likely an enforcement lane. Now, compare that to this. No one is blatantly violating the order, but the schedule was built years ago, and now school logistics, distance, and work hours make the current rotation completely unworkable. That may be a modification lane. So before you file anything, ask yourself 3 questions. Is the order clear? Is someone violating that clear order? Or does the structure no longer work for the child's current reality? Wrong lane, wrong remedy. And once you pick the right lane, the next step is organizing documentation that supports the lane that you're actually in. If your co-parent keeps denying summertime sharing problems, your notes need to prove what happened. But if your documentation is 200 screenshots and no timeline, it's not going to be as effective as you think. Volume isn't the goal. Clarity is. Not your opinion, not a rant, just a clean record of the pattern. Because when summer conflicts escalate, the parent with the clearest timeline usually has the strongest position. Here's what to capture each time in plain language. What was supposed to happen, what actually happened, where the proof lives, text, email, receipt, and how it affected the child's schedule. For example, Friday pickup was supposed to be 6 p.m. Pickup happened at 8:10 p.m. Text at 5:52 p.m. said, running behind. Sarah missed practice. That's clear and hard to argue with. And that's what helps you separate one bad day from a repeated problem. So think less about saving everything and more about recording each incident in a way a third party can understand fast. A clear record, a clear pattern, and a clear next step. And once your timeline shows this isn't a one-off anymore, you have to decide what legal lane you're actually in. If your summer time-sharing conflict keeps repeating, hoping it fixes itself is not a strategy. At this point, you need to make a decision. Are you clarifying confusion? Are you enforcing clear terms? Or are you changing a plan that no longer works? And here's a distinction that really matters. Enforcement means you're asking the court to make the other parent follow the existing parenting plan. Modification means you're asking the court to change the parenting plan itself. Those are very different legal lanes, different standards, different process. Both are real legal actions, and both often require hiring a lawyer. So before the next emergency week, decide which lane your facts actually support. Either way, don't wait for the next crisis to force a decision for you. Summer is often the warning shot. Use it to get clear, get organized, and get the right legal help so your child's stability is protected going into the next season. If this sounds like it might be your summer, pull your parenting plan, review the specific patterns, choose your next legal step early while you still have room to act calmly. That one move can protect your child's stability far better than reacting in crisis mode later. And if you want help applying this to your situation, reach out and we can talk through your options. We help Florida parents assess time-sharing conflicts and map practical next steps based on their actual facts all the time. Until then, I'm Vanessa Vasquez de Lara, founder of the Vasquez de Lara Law Group, where we make lives better in and out of family court.